Hi friends, Attorney Priscilla Deniz here to discuss the new Biden executive action for spouses of U.S. citizens. I have so many people asking me questions about this, and there's so much misinformation out there. So I'm going to make a series of small videos if you're watching this on Instagram. If not, this is going to be one long video and we're going to break down everything for you. So let's get to it. This is not a law. Okay, this is an executive order. An executive order is sort of like a mandate that the president does to direct the agencies to implement existing laws in a certain kind of way, because a president cannot create a law. Okay, that's not our system. Okay, so in the past, some examples of other executive orders that the president has made could be, for example, DACA. If you remember this relief for people that came in as children and went to school here, they get certain benefits, okay? That was made by executive order. Now, it's very important for you to understand this concept. Why? Because I'm seeing a lot of misinformation out there. A lot of people are calling me with questions, asking me about this law. And people are very hopeful, and I do want you to remain hopeful, but it's very important that you understand and realize certain patterns that we've seen throughout the history of this country. What have we seen when there are executive orders done in favor of benefits for immigrants? In the past, what we've seen is that these orders have been challenged in court, okay? And the challenging of these orders results usually in a halting of the programs. So this actual executive order, yes, it was signed by the president, but currently, can you apply for anything? No. So if there's anybody out there that is trying to get you to give them money to apply for something, or, you know, telling you that this is something that can be done definitely, that's not true, okay? We need to be very aware. We need to be watching the news. We need to be looking to see if finally this is actually going to go in effect, okay? A little bit later on, I'm going to talk about why it is a good idea for you to already be, you know, talking to attorneys, seeing if you do qualify for this, and getting your things in order so that you can apply for this quickly. So let's talk about what this executive order does, okay? It helps you to apply for permanent residence without requiring you to leave the country. There's a lot of people that are required to leave the country in order to gain their permanent residence after they fill out all the forms in the United States. They do have to go out to do a final interview in the consulate of their country. USCIS will grant what's called a parole in place for 3 years in which you must apply for your residency. That actually means that you're going to be paroled. So it's going to be like if you entered legally, but you did not, you're in place. It's called parole in place, okay? So part of the way that you legalize your status through, for example, a family petition, is that you need to have certain qualifications. One of those qualifications is that you need to have a legal entry, which is why a lot of people need to leave the country, get a waiver for their illegal entry, and then come back as residents, okay? So this is gonna eliminate that process completely. It's gonna allow you to be paroled in place, to have a legal entry without having to leave the United States. And that way, that part of the law that says that if you entered illegally, you cannot get your green card, it's not gonna apply to you, okay? So who qualifies for this? Well, you need to be present without admission or parole. So usually the people who've come in illegally, okay? As of June 17th, 2024, you have to have resided in the United States for more than 10 years. And you need to be legally married to a U.S. citizen or be the child or stepchild of a U.S. citizen as of that same date. Remember, children must be under 21 to qualify, and also the child-parent relationship must have also been established before that mentioned date. Spouses and children of legal permanent residents do not qualify for this. Also, people who have other issues in their case other than an illegal entry, such as maybe criminal issues, or maybe this person came in and out of the United States illegally more than one time. This doesn't mean that just because you have a criminal issue or you came in more than one time, you're automatically disqualified. This is just an example. And if that's your case, we must have a thorough consultation to see if you can still qualify, because there are ways for certain people to qualify despite those factors, okay? For people who have been in immigration court proceedings, also, there is a very careful analysis that must be made to see if you can qualify by doing some extra things in your case, okay? So maybe it's possible. We don't know yet. So when is this available? Well, nothing's available as of yet. As I mentioned before, there are no forms to submit, and we do not know the exact documentary requirements, nor do we know what the standard of adjudication will be. If this executive decision ends up going through, it looks like it will be by the end of the summer, where we'll have some type of forms or some type of other guidance, okay? We have to be vigilant of the Federal Register, whatever that says. So what can you do in the meantime? Well, start gathering your evidence of the bona fides of your marriage and also your 10 years presence. This is pretty much all we know about this executive action. Like I said, we don't know how they're going to adjudicate it. So all we can tell you right now is to just start gathering your evidence and start speaking to an attorney to see if you're one of these people that have other little details in your case that you need to take care of before. Immigration is slow. Okay, very slow, so you have to be very patient. The waiting times that we're seeing currently for regular parole in places is about a year or more, okay? So don't expect this to be something very, very quick. If you have a 601A waiver pending and it gets adjudicated, you get approved, I would advise you to go through with that approval unless the forms are already available and you've submitted your case for the parole in place, okay? Now, even if you submit your case and the forms are available, what have we seen in the past with other executive actions? A lot of people have taken that step to submit the case and then it gets blocked in court. We don't know if this is gonna be challenged in court. We really, really think it will because of the history of how executive actions made in favor of immigrants do get challenged in court. But you know, it's depending on when it gets challenged in court. If you qualify for this, I would say apply. I would say apply even if it gets blocked in court, because you probably don't remember, but since I work this every single day, I can tell you that in the past, I remember when the DACA executive action was challenged, a lot of people actually got their DACAs approved before it was challenged. Then it was challenged, and then all the new people that wanted to get their DACA were not able to. So as soon as you can submit your paperwork, submit it, okay? Even if it gets challenged and then later on you can't do it, this is my personal advice. I like to have plan A, B, C, and D. So my advice is to apply for everything that you can, okay? These things don't really cancel each other out as of right now, as far as what we know. If you, your family, or any friends are in need of an immigration attorney with more than 10 years of experience, please give us a call. We would love to be part of your immigration history here in the United States.